degree.
Your suit.
Yes.
Your suit for divorce was decreed.
Yes, because he has also filed a counter claim.
Both for divorce.
Both for divorce.
Right.
It was allowed. Now
Your suit was allowed or both were allowed?
he filed a counter claim claiming, denying my allegations but asking for divorce.
Divorce was granted on your allegations. Yes.
Now what
25,
has-
26, yes.
Now what has happened? The custody of the child was given to the husband, and a permanent alimony of 10,000 per month was granted. Being aggrieved by that, I have come up before your lordship by filing two appeals. Filed by the wife against the husband. In the matrimonial suit, the husband also filed a counterclaim seeking for divorce. In the matrimonial suit, I filed two applications. One is under 25 for custody for alimony, and 26 for custody of the child. Suit was decreed.
Your suit. Your suit for divorce was decreed.
Yes, because he has also filed a counter claim.
Both for divorce.
Both for divorce.
Right.
It was allowed. Now
Your suit was allowed or both were allowed?
he filed a counter claim claiming, denying my allegations but asking for divorce.
So divorce was granted on your allegations. Yes.
Now what
25,
has-
26, yes.
Now what has happened? The custody of the child was given to the husband, and a permanent alimony of 10,000 per month was granted. Being aggrieved by that, I have come up before your lordship by filing two appeals. One for the custody, one for the alimony. During the pendency of this appeal, lordship, the son attained majority. So that
custody-
appeal has become infractious. 168 has become infractuous.
That is also happening before us.
No. 169, lordship. The alimony was granted 10,000. Thereafter, I filed a 125, and it was enhanced to 12,000. She is getting per month. Now I filed this application for permanent alimony.
You have filed an appeal against that permanent alimony order.
Yes.
But it should be FMAT then.
If it was
FAT is appearing as FAT.
now it is
It's against
FA number
an appealable
169
order.
of 2005.
That's not a decree. And we will direct that. So what is the appropriate order for?
Now, appropriate order, lordship. Now I am claiming 1 lakh rupees for per month for alimony
So virtually enhancement.
enhancement.
What was Justice Das and Justice Sen's order?
Justice Das and Justice, that is the order. It was referred to mediation.
Failed.
Mediation failed, but in the order they have their lordships are directed to file affidavits. Only the word is that we suggest instead of monthly alimony, the parties should reach at a quantum towards permanent alimony to the end matter for all times to come. For such purpose, the parties should agree to reach a
You're reading from
Position-
which portion?
order of 19th of January 2020.
Yes, which page? First page.
First page. One
Suggests that yes. So a lump sum quantum.
lordship.
That was the suggestion. Yes.
Parties are directed, second last directed to file affidavit before the mediator, and if they want, they may be assisted by their learned counsels. As per the direction, we have filed an affidavit of assent before the learned mediator. Now, lordship, kindly
Yes.
go through this.
So mediator, it failed before the mediator.
It was failed before the mediator.
Both
They-
parties filed affidavits.
No, kindly go through this. The husband
Read.
filed this application that we need time to file the affidavit of assets. But thereafter, they have said that since there is no specific direction of filing affidavit of assets, only affidavit, we are not inclined, and ultimately the mediation failed. Now, if your lordship, this is coming before your lordship, may I be permitted to serve copy upon Mr. Ashit Bhattacharya, who is appearing for the husband, and fix a date for hearing of this application has been served.
We'll direct the department to carry out the necessary rectification, and you will carry out the necessary rectification in your memorandum so that it is reflected as an appeal from an order, from a final order of alimony. So it will be a FMAT. We'll place it under Order 41 Rule 11 and then hear you on that. It has to be admitted first. Nobody pointed out.
Right.
If it's appearing as FA first appeal, how can it be a regular first appeal? It's not a decree. 25 is not a decree. It's an appealable order.
Lordship.
Appeal lies against that.
Whether it is required to be admitted under Order 41 Rule 11? Because
Definitely, any misappeal is required to be admitted under.
Lordship will kindly direct.
That's a formality, Mr. Right. Questions of where is the memo? We can't find the memo. Let us find out the memo first.
What is missing, I suppose.
No, memo is here.
Memo is it? LCR was called for, Lordship. I have prepared a paper book also to that effect.
Paper books have been
No, it has been found.
paper books have been prepared.
Sir,
Serve. So you have got 2 copies here. You can file it in court.
now,
You have filed it in the department. Very well. Learned counsel appearing for the appellant wife submits that the present appeal has been preferred against an order of grant of permanent alimony. Full-stop, the wife, comma, being dissatisfied with the quantum of the same, comma, has preferred the present appeal. Full-stop, we find that since the impugned order is an appealable order and not a decree, comma, the appeal should have been classified as a first miscellaneous appeal. Full-stop, next para. Accordingly, the department is directed to reclassify the appeal as a first miscellaneous appeal. Full-stop, such necessary reclassification shall be done within a week from date. Full-stop, the file be sent down immediately to the office for such purpose. Full-stop, next para. However, comma, in view of substantive orders having been passed in the matter and paper books having already
no,
been
Lordship, possible. I've been instructed, the paper books are ready with me. I will.
and
file.
paper books having already been prepared by the appellant wife, comma, we deem that the appeal has already been admitted. Full-stop, accordingly, the appellant is directed to file the requisite number of paper books by tomorrow. By tomorrow,
1 week, Lordship. Give me.
within a week from date, and serve advance copies thereof on the learned advocate for the respondent. Full-stop, next para. Upon reclassification, comma, reclassification and filing of the paper books, trial court records have arrived. Comma, the office shall furnish a report as to whether the appeal is otherwise ready for hearing. Full-stop. Upon such report being furnished and the appeal being found to be ready for hearing, upon recategorization, comma, liberty is granted to the parties to mention the appeal along with the present application for hearing.
Grateful to you.
File your paper books immediately. এটা ডিপার্টমেন্টে যাবে, বলে দিতে হবে রিক্যাটেগরি এই অর্ডারটা দেখে নেয় যেন রিক্লাসিফাই